The remedy might not be, could not be, we say, to take the money or property of innocent third parties who in effect purchased at full value without notice of any of the alleged failings on the part of the directors. Because the appropriate remedy under section 996 on these facts could only ever be against the directors said to have acted in bad faith, that cannot be maintained without identifying which directors are alleged to have acted in bad faith and specifying separately in relation to each director what he or she did, when he or she did it, and how that amounted to bad faith. And we say to do so separately in relation to each of the 13 transactions. Because it may be the case that not all of the directors were in office for each of the transactions, and therefore you have to identify separately the wrongdoers and what they each did. And the only alternative would be to plead and in due course prove a conspiracy between the directors to injure by lawful means. And that's not being done, because it would require Zedra to say in respect of each director, when that director joined the conspiracy, the steps taken by that individual director in the conspiracy, and require Zedra to demonstrate that the director's sole or predominant intention was to injure.
Well, hold on. I mean, you don't. I mean, this is a petition under section 994. What they have to establish is unfairly prejudicial conduct of the affairs of the company, or individual acts of unfairly prejudicial conduct. They don't have to plead a conspiracy and meet the requirements of a common law cause of action in conspiracy.
Not in a 994 petition, my Lord.
No.
The alternative way of obtaining relief would be to plead a conspiracy.
Yes, but this is a 994, and they can say, can't they, as a matter of, I'm not saying it's the case here, but as a matter of theory, the board did come together to do us down, and that constituted unfairly prejudicial conduct.
My Lord, yes, that's just one moment they couldn't. I said this is the alternative way.
All right.
But they have to plead and prove the bad faith on the part of the board.
Oh, I follow all that. I follow what you're saying there. Perfect. It's just moving into a common law conspiracy was slightly...
Well, not only because should they be allowed in 994 to be able to plead a claim which is akin to a common law conspiracy without identifying what the individual directors are said to have done. So 994, while it's a wide jurisdiction, doesn't say you can get round what you'd need to prove elsewhere. That you can just say the board without identifying the acts of the directors on the board. So I'm simply saying it's an alternative way they could have approached.
No, I see.
But I mean, is that absolutely right? I mean, if the board's actions are fraudulent, I mean, can be properly alleged to be fraudulent, then, I mean, whilst one would often say the chief executive officer, whoever it was, had proposed the action that was fraudulent, and it was fraudulent in this way, you can make an allegation against the board of a company that it's behaved fraudulently.
My Lord, you can, but you have to identify the individual mind in that. I think that was part of something that came out of SOFA, the Swiss Independent Trustees case.
Well,
sorry,
I mean, those are all different cases, Stanford and SOFA. I mean, of course, if you're alleging a fraud by a person, you have to allege which person was fraudulent. But if the conduct of the board was fraudulent, in other words, they passed a resolution, this is this case, where what they did in passing resolutions and issuing shares is said itself to be essentially dishonest, right? And victimizing Mr. Chase's client. So if that is correct, then you don't need to go through each member of the board on your lovely list here and say they were all did this or that or thought this or that, because the allegation is that the board's resolution was a dishonest act on behalf of the company. And that constitutes, within the words of section 994, that the company's affairs are being or have been conducted in a manner unfairly prejudicial to the interests of Zedra.
My Lord, with respect, I don't think that is possible, because you have to identify within the board. So it was the Stanford Bank, International Bank.
No, but I think you're misunderstanding my point. It's a pretty simple point. If the board all get together and they sit on the 14th of January and they resolve to send Mr. Smith to steal somebody's money from his wallet, and that is recorded in the board minute, then you don't need to say which members of the board were dishonest. They were all dishonest because the board unanimously passed the resolution to do that.
So you say they were all dishonest, my lord?
Yes, but that's what they say here, isn't it?
Well, I don't think it is. We'll come and look on at what they say, my lord. But we say they don't do that. But you'd have to say, in my submission, that some member, at least one member of the board was dishonest and identified. You may say they were all dishonest. We can say Respondents 1 to 7, who were the directors in office at the time, were all dishonest because they got together and passed this resolution for this particular purpose.
I mean, I think it's useful to look at the paragraph you're complaining about, because, which paragraph is it?
44, my lord.
It's 44. Well, we are looking at it. And that's the only pleading for this purpose.
It is, my lord, yes, for the purpose of the dilution of the shares.
So the directors, acting in bad faith and for an improper purpose, have taken steps to dilute Zedra's minority shareholding, which is a breach of the duties set out at paragraph 9. That's the director's duties.
There are no director's duties, my lord, yes.
But that doesn't matter for this purpose.
No.
And then they say, well, they particularize it.
And my lord, they don't say the board got together, save if one, so 41.1 is a breach of the information obligation, says you didn't give us enough information. 44.2 is you didn't offer them to us at a reasonable price. 44.3 is that, in fact, it's a sort of, we know we consented, but we didn't really consent because you didn't give us sufficient information. Then 44.4, dilution in these circumstances, in the circumstances above, is contrary to the legislature's expectations, set out as 16.1 and 22. 22 is irrelevant, my lord, because that's the threshold requirement, which is gone. But 16.1 may be worth looking at, which was on page 102.
But isn't the fourth one the most significant for this purpose? Part of a concerted attempt by the directors, that's all the directors, to prejudice Zedra's interests as a shareholder, which included the actions described at 24 to 39 above.
And was for an improper purpose. My lord, there's no separate improper purpose case open to them.
Well, the improper purpose is to dilute them.
Well,
improperly.
In bad faith.
In bad faith.
It's only in bad faith.
Yes, yes. yes.
So,
I mean, I'm looking at it, I mean, you know, speaking for myself, I don't think it's very fulsomely pleaded. I completely understand that. And this has never been amended, has it, for 2.5 years or something?
Never.
You know, normally in a case where somebody takes the pleading to the Court of Appeal and says, look, we're going to criticise every page of it, pleaders take a little closer look at it and say, well, actually, what we meant is this or that. But
we have been waiting for it, my lord.
Very boldly, the respondents to this appeal have not done that.
Well, yes.
But I mean, looking at it as its best, I mean, this does appear to be an allegation that the directors, as a whole, entered into action which is said to be in bad faith.
Well, part of a concerted attempt by the directors, one has to. This is a mere assertion, my lord, without actually pleading of a factual matter. And when one gets...
Then traditionally you ask for the facts and matters, don't you?
Simon, I didn't catch.
Traditionally you ask for the facts and matters.
Well, yes, but we shouldn't have to, my lord.
I understand that, but traditionally you ask.
Well,
I mean, one of the strange things about this is there is no request. There's
well,
no amendment and there's no request. So we're in the Court of Appeal arguing pleading points.
Well, my lord,
from the common law perspective, that's a bit odd.
well, my lord, it's exactly what happened, I think, in the sofa case.
Well, it may have been done before. It doesn't affect my reaction.
I mean, the sofa
the
case...
thing is that a request for particulars is not designed to make a claimant's case for them, I think is perhaps the point you've made. So in paragraph 44.2, which is really critical, I think, to the case that's being made, there's no pleading of any basis of any obligation to offer Zedra any shares. I mean, what I find odd about this pleading is that it said that a series of share issues have unfairly diluted Zedra's shares, but no details of any sort at all are given about those share issues. We're not told what the consideration for the issue of the shares was. It's not alleged that the shares were issued at less than market value, whether that was for cash or for the transfer of non-cash assets, where it's not alleged that it was in breach of any preemption rights which Zedra held. At the moment, I mean, the difficulty I have is that I don't really see the facts on which it's asserted that there was an unfair dilution of Zedra's shares, coupled with the fact that in that absence it's difficult to see how one can point to any individual director as having had the necessary improper purposes and intentions. So the general structure of the pleading seems to me to be inextricably linked with your specific point under ground 4 of inadequate pleading against individual directors.
My Lord, yes. We say there's an assertion of bad faith, but that you cannot assert without having the necessary facts and matters there. And
well, I mean, it goes even further than that, doesn't it? That this is clearly the sort of case that Lord Hoffman was talking about in O'Neill and Phillips and Saul v. Harrison, where really the sort of equitable considerations discussed and applied in Westbourne Galleries don't really have a part to play. This is a commercial arrangement with detailed shareholder agreements, detailed articles, complex capital structures, and so on. So, I mean, as Lord Hoffman made clear, it's incumbent on a petitioner to identify the breaches of the articles, the breaches of shareholders' agreements, the breaches of fiduciary duties, or other legal wrongs, which form the basis of the allegation of unfair prejudice.
Yes, well, otherwise you are stuck with the articles, the contract between the parties.
Exactly.
And there is no pleading. The only pleading of legitimate expectation long
Well,
gone.
the only pleading of legitimate expectation is that they won't be unfairly prejudiced. Well, that's, I mean, we don't need to plead that. I mean, that's what Section 994 says.
Yes,
That's actually what they plead in 16.1, I think, isn't it?
Effectively.
We won't, I think, yes, I mean, it says that at the top of page 103 in our bundle,
My Lord, yes.
so that Zedra had a legitimate expectation at completion that the company and its directors would not take any step after completion which unfairly diluted the size of their shareholding. Well, I mean, they don't need to plead a legitimate expectation. That's what Section 994 is there to remedy, that if there is unfair dilution, the question is what makes it unfair?
My Lord, yes.
And we don't see anything there. So the unfairness has to lie in the sort of items that Lord Hoffman was identifying. And it seems to me your point here on 44 is that we don't see any of that pleaded.
We don't, my Lord. The only way round that would be to say bad faith.
Well, I don't, with respect, think even that's good enough. I mean, bad faith doesn't exist sort of in the abstract. Bad faith exists in the way you conduct yourself. You exercise a power in bad faith or something of that sort.
Oh, no, sorry, so I'm not saying just bad faith is sufficient. You've got to say what the bad faith is. What have you done?
Quite so.
And that's why we say that there is no particularisation here at all, which would give rise to any valid complaint.
I mean, that's what I have a difficulty with at the moment. I mean, paragraph 44 is pleaded, I think, as a breach of fiduciary statutory duty by the directors. I mean, wrong, because it said that that it was a breach of the duties set out in paragraph 9. But I mean, for example, with 44.2, doesn't seem to be any pleaded basis for saying that there was a breach of statutory or fiduciary duty involved in not offering shares to Zedra.
There isn't, and the same can be said in respect of each of these allegations. But without 44.2 amounting to unfairness and the base for unfairness, the petition just doesn't run.
it's pretty unsatisfactory actually, because the 44.4, which for me, from my mind anyway, is as close as it gets to saying what it's complaining about, as my lord points out, doesn't really say what in material terms is a breach of what. Why shouldn't they prejudice Zedra's interests as a shareholder if everything they've done is according to the articles and the constitution of the company? But it does say, which included the actions at 24 to 39, so you've got to go back to the whole of the rest of the pleading to try and work out what is said to be a breach of duty. When you do that, you don't see any breaches of duty. I don't mean breaches of fiduciary duty by the directors. I mean breaches of the constitution of the company.
That's right, my lord. That's why we are really in this is, as Lord Justice Richards rightly pointed out, this is not a quasi-partnership small company where everyone's working on understandings, common understandings.
I mean, this is also, I mean, we're in a situation here where, I mean, this is a sort of classic tech startup, of which there are many in modern times, where presumably they've raised capital at various stages in the life of the company to purchase companies like Protein and other companies over the years. And of course, they do dilute other shareholders every time you raise capital in a startup, whether it's tech or not tech.
Indeed.
And that's the natural order of things. And are we shown anywhere the articles? Are the articles referred to in the petition? I mean, that would be...
They are referred to in terms of the co-sale rights.
Just the co-sale.
The articles are in the supplemental bundle. And there is a free ability to allocate and issue new shares, unrestricted with no preemption rights.
There's no allegation of any breach of that.
No, but they'd have to say you have this obligation under Article 3, as it happens, and you breached it in this particular way.
Yeah.
And this, if you don't do that. In circumstances where the irony is, of course, they've made millions and millions, hundreds of millions of pounds out of all of this. Some £285 million on the listing. They sold 85% of their shares, Zedra Trust shares on this. More than tenfold the value at the time that they entered into the SBA back in May 2011. So while, my lord...
yes, I'm not even sure that if you issue new shares for good consideration, for full value, the existing shareholders' relative holdings will obviously decline. Whether that's properly described as dilution, I'm not sure. I mean, what it is a reduction in the relative size of their shareholdings. Diluting is when you add water to debase a substance. Well, I'm not sure that an issue of shares for full value dilutes in any sense at all, other than just reduces your relative size of your shareholding.
Yes.
Of course, if that's what's meant by dilution, fair enough. But there's nothing wrong in itself in dilution. The unfairness comes as if the company does not receive full value for the new shares.
But that's right, my lord. And
may come.
The irony of this is that they are seeking what we think are 4.78% of the company without having paid a penny for it. A company which has grown enormously. And although your lordship, as Master Rolls refers to as a startup company, it is quite long established.
Yeah, but it was a startup at one time.
In 2004, my lord, yes, it was a startup.
It's progressing through to being, well, it's now been listed, as we learned.
It's listed, my lord. It's got a market capital of £6 billion.
How's the share capital? I mean, we've got in the petition figures for share capital as at the date of the presentation of the petition. But has the capital of the company altered since then? Have new shares been issued?
It has, my lord, yes. It's now 1.2 billion shares in issue.
Right.
So according to the...
I mean, no complaint is made in respect of most of those share issues. So there are now 1.2 billion shares.
Yes.
Are they all... Well, maybe I don't want to get into too much detail about that. So that it's gone... What was it at the date? so far as this petition is concerned? How many shares are we talking about? I think they give the figure somewhere.
They do, my lord. It was 4 million, paragraph 4, 4,317,000.
Paragraph 4.
Page 99. But as part of the listing, the shares were split, and then further new shares were issued.
4 million, yes, I see. And the 1.2 billion, that's the number of shares in issue, is it?
That's the number of shares in issue now, as at the confirmation statement dated the 19th of March 2021.
I mean, are there any of those as a result of just capitalising reserves, bonus issues?
Not as far as I'm aware.
No, I mean, they're all new shares, which have been...
The original shares were split
right.
upon the listing.
Right.
So they became, because they were no longer £1, originally £1 shares.
So the 4.3 million, I just want to get a sense of this. 4.3 million, were they £1 shares?
I think so, sorry.
Well, maybe perhaps you can just let us know at a later stage.
There were £1 nominal value shares, my lord.
Of £1, yeah.
Then all the A ordinary shares and B ordinary shares were subdivided and converted to ordinary voting shares of half a pence.
Right. So I mean, so raw numbers may not be very. I mean, it might be better to give us the nominal value of the issued share capital in total. I don't know. I mean, it's difficult to compare. We're comparing apples and pears. But my basic point was: have there been significant issues of shares for consideration? Since the presentation of the petition?
Yes, there have been. I can't tell you how many, but there were some before listing, there were some on listing.
Okay.
Sorry to change the subject, Mr Ashworth, and I would be grateful as well if you could help my lord with those questions. But I'm just looking at ground 4, which for my part I still regard as the nub of your appeal. And the complaint you make is that the thing should have been struck out because pleaded allegations, failed to plead effectively allegations of bad faith against every director. Couldn't be done against a group of individuals and needed to particularize statements, actions, and states of mind of each individual. But I mean, I'm not criticizing the drafting, but your allegation is really a bit more fundamental than that, isn't it? I mean, that is, we know the argument we can have about Stamford and Sofa and all those other cases. But the allegation is more fundamental. That what it fails to say is why the allegations amounted to bad faith at all. Why the facts they plead, namely the dilution, I think it's a semantic point, respectfully to say, whether dilution is itself improper, probably it's not. But why the dilution, which takes place in every company as it expands, was in itself improper or inappropriate or in breach of some legal right. And that's the fundamental complaint you make about this petition, isn't it?
It is, my lord, yes.
So, I mean, you haven't actually got a ground of appeal. So if any drafting needs to be done, maybe it needs to be done on both sides.
Well, my lord, we say that it falls in the bad faith because they simply haven't said, they've just made an assertion there was bad faith. And they haven't given the particulars of the bad faith.
Yes, but you acknowledged when my lord asked you, you said, well, it could amount to a satisfactory pleading if it were bad faith, but it's not really correct because it has to be. I mean, you can do anything. You can have a bad. Well, if the articles allow you to do X and you follow the procedures properly, saying that you did it because you didn't like somebody is actually quite unlikely to be successful. I mean, it may be. I think I can imagine circumstances where it could be, but you know, that's not this case. I mean, there has to be some breach of a legal right, doesn't there?
Well, there has been. What you're postulating, effectively, is a lawful means conspiracy.
Yeah, but that's not what's pleaded.
No, quite.
And I mean, I've just looked through the pleading very carefully, the petition, searching for articles, because that's the most fertile source of breaches, that you break the articles in order to further your bad faith. And it's all very mechanical. They simply plead you did this and you did this under the articles. So you've got quite a fundamental allegation, haven't you? It's not said that there was anything done that was inappropriate or wrong or
that's why we complain about the bad faith argument, because that's all that is said against us in each of the three relevant paragraphs. 44 is the only one that remains, because the others have gone because of being rectified or it's gone on the listing. On 44, which is the dilution, all they say is you acted in bad faith. And we say you don't give any particulars of who acted in bad faith or what they did in respect of bad faith.
No, but I mean, as my lord says, if you're raising capital and you issue more shares, which has the effect of diluting another shareholder, there isn't any reason why you shouldn't do that if you pass all the necessary resolutions. So the fact that well, I mean, it's not a meaningful allegation of bad faith to say you did that unless you could show the company didn't need the money or there was some improper, you were doing it, for an inappropriate purpose. I mean, they say it was for an inappropriate purpose, but they don't say the business of the company didn't need the money or they didn't need the...
Well, by contrast, my lord, by contrast to 27 and 37, where they say acts were done without a legitimate commercial purpose.
Yes.
They do not say that here.
Well, except in 44, whatever it is, 42.4, they do refer to those paragraphs.
But those paragraphs are particular earlier acts were not done for legitimate commercial purposes. Yeah. So the earlier bits were what we say is the mistaken alteration of the article, which was corrected, which is the paragraph 27, and paragraph 37, which was the what they term removal of co-sale rights, and there's no such removal at all. But anyway, that has gone because the articles have all changed under the listing. So the only ones left is 44. But they do not say, and the judge noticed...
Sorry to interrupt you, but the changes to the articles, there were two complaints made. One was the first change to the articles, which you say was a mistake anyway, and you put right. But what about the other? The other complaint is made about the fact that what do you call them?
Co-sale rights.
Co-sale rights were conferred on the B ordinary shares that had converted from all the A shares except the A4 shares, which happened to be the ones owned by Zedra. You're saying that's all changed as well?
That has changed because those co-sale rights under the articles that existed then have all gone on the listing. So that's no longer...
I see. Well, that's news to us as well.
Of course, it is news to you, my lord, but one would have expected an amendment from the petitioner to say, well, now it's been listed, we've got to amend to explain what it is. We say that this amounts...
When were those changes made to the articles?
The final article adopted in September 2020.
September 2020.
September 2020.
So since the hearing before Judge Eyre?
Yes, my lord. So, we don't accept, my lord, there was any removal of those co-sale rights anyway, because it was their own action. They chose to convert.
Well, no, that isn't the complaint really, but anyway, you say they've gone. So but I mean, what is said in 44.4 is that the dilution was part of a concerted attempt by the directors to prejudice Zedra's interests as a shareholder. So that is being said that the dilution was done for the purpose of, as I read it, prejudicing Zedra's interests. Difficult to see that that's a proper commercial purpose.
Sorry,
well, in 44.4 is stemmed because in 44.4 the allegation is that the dilution of Zedra's shareholding was part of a concerted attempt by the directors to prejudice Zedra's interests. So it's those issues of shares which are said to be, brackets part of, close brackets, a concerted attempt by the directors to prejudice Zedra's interests and as a shareholder. But that has to be, I mean, that's the assertion. That there has to be a properly pleaded basis for that assertion.
So the point I was making, obviously not making very well, is they do not say the issuing of them shares themselves and the raising of money was for no proper commercial purpose.
Well, I mean, if it was a proper issue of shares, I mean, unless, as my lord said, the company didn't need the money, I mean, that is a possibility, I suppose. If it did have a commercial purpose, why would it be an attempt to prejudice Zedra's interests?
Plainly isn't. It just isn't. So
it seems to me 44.4 is just a sort of assertion. It's a sort of conclusion, as it were, doesn't it?
Well, that's the point we tried to make below,
Yes.
and I was trying to make now, that we've got an assertion of bad faith without the necessary facts, matters, and particulars of why that is bad faith and why that gives rise to the unfair prejudice. We say, in order to make that out, because especially if you're looking at a situation where you're saying which director is the wrongdoer, which director is the party against whom an order should be made, we say you've got to identify in respect of each of the directors. It may be that they can say that on a board, Master Roll's observation, that there was a particular board meeting on this particular day, and they all sat down and said, let's issue these shares, let's take this investment from KKR, £100 million, let's issue them some shares. Not because we want the money, but because that way it'll sort out Zedra. Because what it ignores is that there's no reduction in value of Zedra shares at any stage. Zedra shares keep rocketing up and up and up. And there's no stage they say, as a result of this, our shares were worth less, which would be, in my suspicion, a necessary part of unfair dilution. Because if you're doing it to say, right, you had shares worth £100, as a result of this dilution, your shares are now worth £60, then that might be an unfair dilution. If you say you've got shares of £100, and as a result of taking on this further investment, issuing more shares, your shares are now worth £120, how could that conceivably be unfair dilution, if it's dilution at all, as your lordship says? It simply doesn't work. So, but also, sorry if ground 4 is not, it was intended to capture just this. That was the basis of it. And I just turn my back on your lordship. Well, I don't know whether it would assist to examine in any more detail the other two allegations in order to show that their 44.4 simply doesn't work. Or whether...
I mean, what the judge said was that it was an allegation of collective ganging up. Right?
Well, not yes.
So you say that's not good enough.
So firstly, that's not what's pleaded, and secondly, that's not good enough.
Simply it's not pleaded, but it sort of is. I mean, in my point about the whole board.
But one would expect, in that sort of situation, on this particular day, these directors got together and they decided, for no proper purpose other than to do down Zedra, to take the following steps. ABC.
I mean, if you look at the way Mr Chasty's skeleton answers this point, he says that there are really 3 allegations made against him, and made against you, sorry. I'm sorry, I was looking at it a second ago, and I've just... Sorry, it's at 49 of his skeleton. The allegations of bad faith relate to the following conduct described in the petition: the removal of co-sale rights, the preferential treatment of other shareholders converting their B shares, and the diminution in Zedra's percentage shareholding in THG. But what none of that says is why that was wrong.
My Lord, no.
I find this very unsatisfactory, Mr Ashworth, that we're sitting in the Court of Appeal with a 1.5 day hearing where the facts have changed dramatically since the first instance hearing, and nobody seems to have done anything about that.
Well, my Lord, with respect, I don't think it's for us to do anything about it.
No, I'm not criticising you. I'm not really criticising anybody. I mean, if you're saying, well, we have to deal with the matter as if it was the same as it was all those months ago before the judge, fine.
We're saying, my Lord, that the only allegation which could possibly be relevant is the 44.4, so the 44 allegation, which is the unfair dilution. We say that doesn't work for the reasons we've been discussing.
Yeah, but you don't say it doesn't work because of what happened since. You say it doesn't work anyway.
That's right, but that one doesn't work anyway. And that wasn't unfair at the time, it isn't unfair now.
Yeah.
So we say it simply doesn't work because they haven't said you did this in breach of a rule, an article, the law, or some legitimate expectation.
Yeah, I mean, I get that point, but I do think you ought to put it down in writing, because I'm not sure it's precisely what your ground for does say.
Well, certainly we will.
Well, over lunch. I mean, you carry on. I think we've spoken more than we probably needed to.
Well, I'm slightly taken out of.
Slightly taken you out of your it might be said.
Yeah.
I'm just wondering where your lordships would find it most helpful for me
Well,
to go
I mean,
next.
I think that you started and we very rapidly derailed you on your first point, and you'll have seen that I, at any rate, was having difficulty in seeing how you could make good the case that whatever findings were made, court would never order an issue of shares, even if those were ordered to be paid up at full value by those who have been found to be wrongdoers. I mean, that would not involve any infringement of the A1, P1 rights of the innocent shareholders.
Well, I think I think you're right on that, my lord, but that's not how it's put. And we can
Well,
only
all
meet.
it's put is that there should be an issue of shares. It doesn't actually say anything about how, I don't think, about what the mechanics for the issue of shares should be. Does it,
Which says, in order the company issue shares. So
well, only the company can issue shares,
yes,
obviously.
It's page 116.
Yes.
But it doesn't have the cunning twist, if I may put it that
No,
way.
but that's the sort of thing that would be worked out at that stage. I mean, you're coming here saying you should strike out this paragraph of the prayer for relief because the court could never order it.
In the terms in which it is sought.
Well, no, that's which one is it?
It's 116, subparagraph 6, my lord.
Yes, but it doesn't say anything about how the shares are to be paid up, does it? So that has to be worked out. You can't just issue shares. It's got to be either paid up by a capitalisation of reserves, or it's got to be paid up by a payment for a value, cash or non-cash. Now, I mean, if this was if this would have a significant dilutory effect on other innocent shareholding shares, then that would be at the very least a matter of great concern to the court before it ordered it. But it might avoid that problem in the way I've suggested.
My lord, yes, just so we put in context, it's 4.78% is the alleged dilution. So one assumes that that's what they are.
Well, is that right? Because you tell us there's been massive issues of shares since then. I mean, it seems to me this is all a bit. I mean, we don't really have the material to know what that means. I mean, if there have been very significant issues of shares for consideration since the petition, then it seems, and they're not complaining about any of those issues of shares, it's difficult to see why they should be restored to a percentage which, as it were, ignored those subsequent issues of shares.
Well, we agree entirely, but the relief they're seeking. So,
but I mean, that is something that could be worked out if the substantive claim was made out. I mean, you know, I've said this before, but I mean, the fertile ground for this appeal seems to me to be for you to try to show that the substantive grounds pleaded cannot succeed in allowing the court to consider granting relief under Section 996 because of what we've been discussing.
Oh, yeah.
The sort of snapping at their heels and saying the way they formulated 6 doesn't really is incomplete or inadequate is neither here nor there, because most pleaders put further or other relief, which would give them. This one didn't, interestingly, I noticed, but they normally do, and it's read in anyway. So the court can do what it wants once it's established a substantive right. But you say there is no substantive right, entitlement, pleaded. It's not good enough, what they say. Now that, to me at least, and speaking only for myself, does seem much more fertile ground for argument than the fact that A1P1 would not be, which, you know, is a last resort, but it would be satisfied if you were expropriating shares from innocent people. I mean, I think we can accept that. But we also can assume that the court is unlikely to expropriate shares from innocent people and will only remedy a wrong that it has found to be committed. The much more fundamental case you advance is that there is no wrong pleaded which amounts in law to a right that can be remedied.
My lord, we do. So I was going back. I'm sorry, I was going back to...
Did you say that to the judge? What I've just said?
Sorry, we said...
There is no right pleaded, no wrong pleaded that the court can remedy.
We've said there was no proper allegation of bad faith, which was the only way in which they could get their remedy home.
So you accepted that just being succeeding in bad faith could get them home?
Well... No, I mean, we didn't accept that. We said that's the first step you've got to get. You can't allege bad faith to make good and otherwise not successful, not arguable, unfair prejudice petition.
But did you make the substantive point that unless they've done something wrong, like breached the articles, or done something substantively illegal, to put it in the vernacular, they can't get home here?
My lord,
and if so, what did the judge say? Your junior is nodding, and therefore I'm assuming he's right, because they normally are.
My lord, I'm grateful that he's nodding rather than shaking his head, going, oh no, oh, what have you done?
I want to see my juniors shaking his head.
My lord, we have the transcript here behind.
No, I'm not. I wanted to know whether the judge mentioned this point, because I may have missed it.
I don't think in the judgment it is dealt with, my lord, because we...
There are 17 references to the Articles of Association in his judgment.
I mean, we've got paragraph 79. Is that...
Well, that's where he deals with bad faith.
There are two questions which need to be addressed. First, whether the allegations pleaded are capable of being the basis for findings that the respondents acted in bad faith. That looks as if it goes to the root of the case, but maybe it doesn't. And or for an improper purpose. So, I mean, that's the root of the case. But maybe second, whether they're pleaded with sufficient particularity. So,
at 81, he noted the.
Yes, I turn to the question whether the matters pleaded are capable of being the basis for findings of action in bad faith.
I mean, the problem I have is that I'm not sure that actions in bad faith necessarily amount to a right to relief under Section 994. Necessarily. Of course, they may well do. In many cases, they will. But you can imagine situations, particularly in a company of this size and importance, where the board would do something that was entirely lawful within the constitution of the company, but one of the directors had proposed it for a malign reason, for example. And everybody agreed, and it was a lawful thing for the company to do, but it did have a bad effect on one shareholder, say, and, well, I suppose that could give rise to an unlawful, unfair prejudice petition, in theory.
If it was both prejudicial and unfair.
Yes, yes.
So one would have to ask those two questions separate, but yes.
So where does the bad faith matter? Oh, I see. Well, I suppose that's... I'm just struggling, really, to see why bad faith automatically gives you an unfair prejudice, right?
Oh, I'm not saying it does, but you'd have to plead a case of bad faith which could convert otherwise non-unfairly prejudicial conduct into unfairly prejudicial conduct.
Is that why they place such weight on information, on the information right? Because they say here, okay, they were doing what they would otherwise be entitled to do, but they had to tell us what they were doing so that we could not be diluted and subscribe for the shares or whatever.
We come back then to the counterfactual we haven't pleaded, which is that we would have bought at the prices that the shares were being offered at. It's rather, you should have inquired us whether we wanted to buy at an affordable price.
Yes, and they don't say what that was.
No, quite. Who determines what an affordable price is?
Yeah.
So subject to the point that bad faith doesn't necessarily equate to unfair prejudice, the point about bad faith that the judge deals with is at 81 to 85, I think, of that's where he answers the first question, and you say he's not grappled with, in fact, that they didn't do anything wrong.
Oh, no, that's right. There's no pleading that they did anything wrong, which would convert it into otherwise lawful acts into the unfairly prejudicial conduct. And dilution, in inverted commas, that doesn't breach the articles or other equitable restraint and has legitimate commercial purpose, can't constitute unfair prejudice. Probably can't constitute prejudice, but certainly can't constitute unfair.
I'm sorry to bang on about this, but I think it's paragraph 85, second sentence. If the petitioner does establish at trial that there were repeated actions which were harmful to it, which lacked a proper commercial purpose, and which were accompanied by a failure on the part of those taking to disclose information which should have been disclosed, then it will be open to the court to infer that the actions were taken in bad faith. So that's effectively deals in a sort of a slightly sidelong way with the legality.
Yes.
The unfair prejudice must be in the conduct of the affairs of the company or an action of the company. So if the board exercises a power or if the shareholders pass a resolution in bad faith, whatever that may mean, it's likely to constitute unfairness, and if it has a prejudicial effect on some shareholders, it may well constitute unfairly prejudicial conduct. As a sort of general matter, one can see that. The question is pinning it down to the particular actions. Why were those actions unfair? What is relied on for saying they're unfair? In looking at the paragraph my lord has referred to, what the judge doesn't seem to do is to pause to ask whether, for example, the issue of shares lacked a proper commercial purpose, because there is actually no pleading that they did lack a proper commercial purpose.
Well, he does note there's a paragraph 81, my lord,
Oh, he does in 81.
In fairness to the judge.
Yes, I see. Well, he notes it, but then
Doesn't act on it.
he does. Yes, I see.
So he notes it, but then goes on 85 as one of his steps is it lacked a proper commercial purpose.
And anyway, yes.
So
Just a minute, Mr. Ashworth. Yeah, I think probably you should address all your grounds of appeal unless you don't wish to maintain them, because we've blown you off course quite significantly and we're not going to make more time, so we'll do our best to, I was going to say shut up, I'm speaking only for myself here, not for any of my lords, but so you can do that. I mean, say what you want to say about A1, P1 and don't be put off by the unhelpful comments from the bench.
not unhelpful.
I mean, you can always say, Mr. Ashworth, well, I'm happy that you've got my submissions in my skeleton, and that's it. But if you want to elaborate them, please do so.
Well, would you indulge me for 5 minutes?
We will.
Just so, because it may assist. I just wish to consult with others, and then I hope in the 5 minutes.
You want to take a break?
Yes. Sorry.
Oh yes.
Sorry.
We'll rise for 5 minutes. That's absolutely fine.
All right.
Live stream will remain on. Yeah. It's not the happening, Nancy?
Oh, I'm going to do a very short bit on it. I'm going to say our basics in writing and then it's going to
What you be 10 minutes?
on that bit actually. Then we get on to the faith again.
Then you get back to that.
Well, I don't know. What I can't understand is whether he's saying he's had the solutions and that's it, or he wants some more.
I know.
I'd be very slow to read him. Very slow. Right, I think.
Will they knock? Or
Yes. Sure, I read all that actually. We really can. Court rise.
My Lord, thank you for the time. I am going to rely almost entirely on the written argument on the AIPI points, subject to a few minor clarifications. So I'm not going to take your lordships to any of the authorities because they're there in writing. Picking up at paragraph 43 of our skeleton argument. My Lords, grounds 2 of our grounds of appeal, in fact, is no longer necessary on a practical level because those co-sale rights which they were seeking to be conferred have ceased to exist. No shareholder now has co-sale rights. In paragraph 46 of the skeleton, my Lord, I have included a wrong reference. The reference to the part of the judgment medical costs for asbestos disease in Wales Bill case should be to paragraph 41, not paragraph 40. The quote is right, it's just the paragraph reference is wrong. Paragraph 51, my Lord, we talk about the unimpugned shareholders. At the date of the petition, they were the purchasers. Since then, of course, there are those who have been buying and selling on the listing, since the matter has been listed. At 52 subparagraph 3, my Lord, that was, we say at the time, was a good and important point, but now it's been overtaken by the listing as there are no threshold limits in the article anymore. Paragraph 55, we refer to Zedra's response, it doesn't seek a confiscation order. And there's a suggestion at paragraph 3 of Malone Friend's skeleton argument.
Sorry, wait, which paragraph did you say?
55, my Lord.
55.
At paragraph 43 of Malone Friend's skeleton argument, is a suggestion there's no taking away of property because the shareholders will still retain the shares they have and the rights attached to them. There will just be more shares in issue. And that ignores the practical effect of any such order, which would be to reduce the value of the shares, the other shareholders' financial resources. And that is prohibited under A1P1. If there were any merit in Zedra's argument, it would faithfully undermine its fundamental premise of having been diluted, because it retains the same shares that it had before the purchase back and allotment of the shares in each of the 13 transactions. It retained the same property it had at all times. Its complaint is that the property it's retained is not worth as much proportionately, and that doesn't, because they don't have the same percentage, but of course it's worth just as much, indeed it's worth more. In paragraph 56, my Lord, we mention the retrospective effect of any such order, and therefore that requires special justification to be permissible, and there is no special justification identified either by Zedra or indeed by the judge in his judgment, and there is none that exists.
So that's paragraph
56, my lord.
I see. So, right.
So the need for special justification comes from the earlier authorities that we quoted.
That comes from asbestos diseases, doesn't it?
It does, my lord, yeah.
Yeah, that's fine.
Sorry.
Yeah, that's fine. I just for my note.
Sorry. And then we look at 59 of applying the asbestos diseases four-fold test of proportionality to cross-check. And those are set out at paragraph 47. Firstly, we say the first of the four-fold proportionality assessment isn't satisfied. It does not serve a legitimate aim which could justify restriction on other shareholders' rights to their property. We say the second one doesn't arise. And then we go on to say in writing that the interpretation doesn't satisfy the third or fourth criteria of the test, as set out at paragraph 47. Indeed, in this case, making an order to this effect doesn't arise. Making an order that the shares be bought doesn't have to happen, because this is a share which can be traded in the open market as listed. So paragraph 61, my lord, we give ground to, but as we say, it's been overtaken by the change of the articles, which Zedra voted in favour of to allow the listing, which removed everyone's co-rights with their consent. And my lord, we then set out at 64 what we said the alternative route to interpret section 996. In subparagraph 3, of course, your lordship, Master Rolls, Judgment Apex Global Management from FICAL, when you describe this as a very wide relief, wide and flexible remedy. Similar statements in Sikorsky and Sikorsky from Mr Justice Briggs then was, and from Lady Justice Arden and Retobian Properties, she then was. But none of those judges have ever suggested the remedy can be this wide, so to take property off an innocent third party. And I appreciate that this is on the basis of as it is pleaded. And at no stage has the suggestion which Lord Justice Richards has said about ordering other shares to effectively to be purchased by the wrongdoers and then transferred or issued at the cost of the wrongdoers. That's never been suggested either by the Zedra in this case, or indeed at any time before in the judge's judgment. So we were literally facing the pleading case as it was, dealing my lord, we've set out in paragraph 65 reference to the authorities where, and your lordships have the point, that Crown or State can't take property off people without compensation. Now, this of course is not what Lord Justice Richards is contemplating might happen in this case, but it's as it is pleaded. There is a claim in the Land Defence Skeleton argument at paragraph 46 that the Human Rights Act and this cannot be invoked to protect those who've acted to deprive, whether knowingly or unknowingly, of what must be assumed to be rightfully Zedra's property. And we simply don't understand that, because no one has taken away Zedra's property at all. But the reference to knowingly or unknowingly is mystifying and incapable of comprehension, where the claim, as far as we can work it out, is that the company did this in bad faith. So I don't see how one can have an unknowing bad faith.
So that's in paragraph
46, and I reference skeleton argument. So we set out our conclusion at paragraph 66, and then at 67 turn on to ground 3. And this is simply the judge misapplying the relevant test in the circumstances of this case in the way that it was advanced. And my Lord, we say that in the way it was advanced, into paragraph 71, this was a claim to relief in paragraphs 3 and 6 of the prayer, which could and should be characterised as perfectly hopeless. And the learned judge was wrong not to have so held. It's not possible to ascertain his reason for so holding because he didn't give any reasons as to why he said it was not perfectly hopeless. There's no reason at all. It's just, I do not accept it as perfectly hopeless. And therefore we say, if this was a truly evaluative decision, it was one which the judge could not properly have come to, alternatively one which he couldn't properly have come to without at least expressing his reasons for it. My Lords, I've counted through grounds 1, 2 and 3, and now turn back to ground 4, if I may. And please, with your Lordships, tell me you've had enough of hearing me on this point, as and when you have. Your Lordship, Master Rolls has said, well, your ground 4 doesn't really get to the gravamen of this case. With respect, it does, because dilution that doesn't breach the articles or any other equitable restriction and has legitimate commercial justification cannot constitute unfair prejudice. In those circumstances, the only fact of it, only the fact of being done in bad faith could possibly render the dilution unfairly prejudicial. So absent the bad faith, properly particularised as setting out, then there is no unfair prejudice. So the allegation of bad faith is the only thing that could possibly save the complaint about dilution. If the allegation of bad faith is struck as we say it should be, then the complaint goes. There is no complaint left. Now, Lords, the Zedra has not filed a Respondent's Notice, so it cannot go behind the paragraph of his judgment. But the distinction in this case between improper purposes and bad faith is of no relevance. It's therefore not open, for example, for Zedra to say they can advance a case of improper purposes, which doesn't require them to plead properly and at trial prove bad faith.
Sorry, let me just understand that.
Paragraph 80 of his Lordship.
Well, I'm just looking first at the petition. Well, what's said in paragraph 44 is that the company and its directors acting in bad faith and or for an improper purpose.
My Lord, yes. But his Lordship dealt with this at paragraph 80 of his judgment.
I see.
So the point I'm making, my Lord, because there's no Respondent's Notice saying that they could advance an improper purpose case without bad faith, it's not open to do so now and say the pleading is somehow safe.
Yes.
Well, as we all know, an allegation of bad faith is an extremely serious allegation to make against anybody, particularly against professionals who are in the position of directors of companies like this. This is not the usual quasi-partnership type company where families, members have fallen out and everyone's being spiteful and horrible to each other and they're involved in an unseemly scrap. The directors against whom the allegations have been made, and your Lordships have a table which sets out who's currently still in office, who's not, are a mixture of executive and non-executive highly reputable directors. On Zedra's case, they've all got together in some manner colluded to do down Zedra. And we say it's wholly inappropriate for Zedra to lump the respondents together and make such serious allegations against them as a group, and do so irrespective of whether they were directors at the material times, because the directorship was changing through this period. And the burden is squarely on the party making such serious allegations to plead and particularize them properly. We say, and I know that Master Rolls doesn't necessarily agree, but we say the allegations should be made in respect of each individual director separately, especially given that questions of bad faith depend on the individual's own subjective state of mind. The question which has to be asked is, what does Zedra plead that the respondents did which amounted to bad faith? And the petition starts, the relevant parts start at paragraph 9 here, where they set out the duties owed by each of the directors to the company. There's no claim of duties owed by the directors to Zedra. Paragraph 27, 37 and 44 are the bad faith paragraphs. And in each of them, your lordships will see that it's claimed that what they did was a breach of the duties set out in paragraph 9, the breach of the duties to the company. And then what follows in each of the sub-paragraphs, each of those relevant paragraphs, are the particulars of the actions alleged to have been undertaken in bad faith by THG and its directors. It doesn't identify which director took which step, let alone setting out his or her subjective state of mind, or even an objective one. And it's the alleged exercise of bad faith which is the basis for claims that the affairs of THG were being conducted in a manner which was unfairly prejudicial to them. And the unfairly prejudicial pleading is in fact in paragraph 48. And refers back to paragraphs 24 to 27, saying the affairs of the company are being or have been conducted in a manner which is unfairly prejudicial. The allegations in paragraphs 46 and 47 are in fact pure contractual complaints, which ought to be pursued, if at all, under a Part 7 claim. We say the judge recognised this in paragraphs 97 and 98 of his judgment, but decided by way of case management decision there was no point in having a separate writ action for it and consolidate. My lords, I should make it clear, of course, we don't accept the contractual claim in respect to the alleged information obligations maintained. We deny the formulation of the obligation, deny breach. In any event, Zedra has suffered no recoverable loss by reason of the alleged breaches, and nowhere do they plead any loss. This pleading is devoid of any claim for loss. So there is no other basis asserted for claiming unfair prejudice. And as we discussed, my lords, it is not asserted the issuing of further shares was contrary to the Articles of Association or was prohibited under the now defunct shareholders agreement. It simply said the acts undertaken by the company were undertaken by the company and its directors in bad faith. It's not just the company, it's the company and its directors. So we say, my lords, that if the allegations, bad faith allegations, are not properly pleaded, as we say they're not, they should be struck out. There'll be nothing of substance left in the relevant paragraphs of the petition, given the sub-paragraphs are not standalone allegations without the allegation of bad faith. My lords, of course we accept that on an accusation such as this, the court has to assume the pleaded facts are true. It doesn't mean, however, the court will not scrutinise particulars of dishonesty or bad faith with care to see if they disclose a sustainable case. And we say if you do that to this pleading, the answer is they do not disclose a sustainable case. Turning to the three allegations, paragraph 27, my lords, at page 106, this is the amendment to Article 6.2, which we say was innocent.
So you're at 27 in the petition?
Petition, well, sorry, page 106 in the bundle. We say the complaint is wholly barren The relevant amendment was an innocent mistake, it was invalid, ineffective, because there hadn't really been no compliance with Section 6 of the Companies Act, and most importantly for these purposes, it's been corrected. Paragraph 37 is what's called, erroneously, the removal of co-sale rights, the A4 shares. There was no removal of those at all. And what it actually comes down to, my lord, is an allegation that the company's directors preferred the interests of the converting shareholders by allowing them to maintain co-sale rights after they had converted their shares. There is, of course, a surprising punchline to this at paragraph 36, that it was on the 16th of March 2008 that Zedra converted its shares, A4 shares, to B ordinary shares, whereupon it lost the co-sale rights. It doesn't allege, for example, that it said to the directors of we're thinking about doing this, will you maintain our co-sale rights, as you've done for the other converters? It simply didn't do that. It took a step unilaterally to convert its shares without reference to any of the respondents. It does not plead, for example, we asked to be treated the same way as the other shareholders, and you unfairly said no. It doesn't do that at all. So if the decision caused Zedra loss, it's not a loss that's properly characterised as unfair prejudice to its interest qua shareholder. It's not even a loss for which any of the respondents are responsible. It was an act of self-harm by Zedra.
Isn't the complaint really is on conferring the rights of conversion on the holders of B ordinary shares who had converted from A, A1, A2, A3 and A6 shares, but not conferring that right on converting A4 shareholders?
My lord, yes, but it wasn't conferred after the event.
No, but why? The point is, if there was unfairly prejudicial conduct, I would have thought it was, I mean, leaving aside the information obligation, it was in not including A4 shares in that list of shares that we see set out in paragraph 33(2) of the petition.
My lord, yes, but the complaint is not, we asked you to do this.
Well, is that? I mean,
and you didn't do it. Because they don't...
No, but what... I know, but it does raise a question, doesn't it? Why exclude the A4 shares from this list?
Because we didn't know they were going to convert.
Well,
so
that's a slightly odd... You hadn't told them. I mean...
Sorry. Yeah. So each of the other shareholders...
Well, they were all in on the discussions that led to a mass conversion on the 5th of September, the date that the articles were changed. You're not suggesting you included Zedra or its beneficiaries in those discussions. I mean, the point obviously didn't arise.
No, the problem is this is a pleaded. You have to accept the fact
well,
it's true.
But what you have told us is not pleaded either. So, on the face of it, there is you for reasons which are difficult to fathom. You don't include A4 in that list. I mean, I note that A5 isn't included either, but you don't include A4. And that's the allegation, isn't it? It was unfairly prejudicial to not to confer on them the right that was conferred on virtually all the other A shares.
But they decided to convert of their own free will.
Who had?
Zedra.
No, that was after the event. That was after they hadn't been included in the list.
But they could have come and said, we're going to convert. Will you please include it? Will you please...
You haven't answered my question. Why were they not included? The allegation that's raised is they deliberately excluded us from the list. Well, that's true. You did deliberately exclude them. And they say, well, there's no good reason for that. You say there is a good reason. But that's would be a matter for trial.
That would be a matter for trial, but here you've got an allegation which says we panicked. And if you read through, my lord, to 37.5. The whole point is that B shares held greater rights to net proceeds on the event of a sale. So they say they reached a view that there was about to be a sale and their financial interests were prejudiced, so they converted.
Yeah, but the allegation of the unfair prejudice, what they say is the unfair prejudice preceded their decision to convert. They were left in the position, weren't they, of having the co-sale rights if they retained their A4 shares, but only having limited capital rights, or converting into B shares and losing the co-sale rights. That was the choice for them. But that was not a choice that was put upon most of the other A shareholders. Well, that's the nature of the case.
Yes, well, the difficulty, of course, is this is all nonsense, but you have to accept it as true. You have to accept this as true.
Exactly.
But what they say is that we converted, fearing there was about to be a sale, and therefore we needed to ensure we got ourselves in the best position for a capital return. Having done that, we've now put ourselves in a position where we've lost our co-sale rights. This isn't a case of the article.
Well, your better point might be, well, there's no pleading of value attached to the co-sale.
There's no pleading of value attached at all. And my lord, it's also one of those ones which has gone anyway because the co-sale rights no longer exist for anybody post-listing. So we say it can't be unfairly prejudicial as pleaded and can't be unfairly prejudicial in fact. What we have is a knee-jerk and commercially irrational reaction from them to a perceived threat which is a figment of their imagination. And they can't say, as a result of what we have done, you have unfairly prejudiced us. So all that is left then is the paragraph 44 allegation, which we have been looking at beforehand. And again, it's important to remember that this is not one which is said to have had no legitimate commercial purpose. My Lord, we referred to the Three Rivers case, and your lordships, I'm sure, know that pretty well. I'm very happy to take your lordships back to the relevant passages, but not if your lordships are fully...
Well, what's your point to get out of Three Rivers? We know Three Rivers, but what's the special point?
You have to plead it properly. You can't make a general assertion of bad faith, an allegation of bad faith. The plaintiff alleges dishonesty must plead facts, matters and circumstances relied on to show the defendant was dishonest. And that is, the defendant must be each defendant, not just saying one defendant was dishonest, but I'm not going to tell you which one it was.
Well, that is obviously right, particularly if you've got, at the time, the relevant time, have you got non-executive directors who are not alleged to be part of the ganging up?
What we don't know is the judge said it's just a collective ganging up.
Well, no, were there non-executive
Yes, there were.
directors? There were.
There were non-executive directors.
Yes. I mean, ganging up is less likely amongst non-executive directors, and except in what I put to you earlier, which is the possibility that the allegation is simply that what the board did was dishonest. But you'd have to have some strong facts to prove that.
And you'd have to have some strong facts to plead, my lord. And that's the important point. You can't just plead a generalised assertion and hope something will turn up on disclosure or in the course of cross-examination, which will make good your claim.
No, I mean, it's just what I was balking at earlier, really, was the suggestion that you can't theoretically make such an allegation properly. It seems to me you can theoretically make such an allegation properly, but it has to be backed up by a proper pleading of why the whole board was in on the act.
So, yes, my lord, I'm sorry, I didn't mean that you couldn't say everyone on the board was thoroughly dishonest. I mean, you can get in this, you often get in small family partnerships. You've got the brother who's excluded, and the other three brothers left in who do.
I mean, the Stanford case, just to be clear, was a case where they were saying they were never going to be able to plead that any member of the board was dishonest. That they were never going to be able to plead that anybody was dishonest. It was just that the circumstances led to an inference that somebody must have been.
Yes, as opposed to the Sofa case, where somebody must have been. And
well, the Sofa case is a very strong case where it was perfectly obvious that people had it, just wasn't going to be possible to know
which one it was.
Which one,
yes.
Until later. That's a completely different situation.
Indeed, Mark, but it shows where you can and the limits of the pleading of fraud.
But I mean, in this case, there's been a fraud trial already of some of these people, I imagine, or maybe they're no longer directors. But
no, it wasn't. The fraud was in the accounts department. It wasn't.
Which is nothing to do with any of these.
Not these directors. I don't think. I mean, I wasn't in that matter, my lord. But
it was Mr. McCarthy, I think, who was found guilty.
And he's not and never has been a director.
Not a director. Okay.
So I don't believe that any of the people, any of the respondents here, have ever been found to be
different.
My lord, yes.
Yes. Okay.
This is round 3, I think.
Round 3.
Round 2 or round 3.
Yes.
Spat over the SBA as well, over the completion accounts as well. So my lord, there will be cases, of course, where a litigant genuinely believes that he's been done down, and genuinely believes that somebody on the other side must have been dishonest in order to do him down.
Can we take the Para 38 example that my lord was asking you about?
37.
37, sorry. Let's say that the board decided to exclude A4 shareholders because they specifically did not like Zedra, right? And for no better reason, without any commercial purpose. I mean, at the extreme of the pleading, that seems to be what is being said. Could that not theoretically be an action by the board which was unfairly prejudicial to the A4 shareholders?
If all the board got together, so all members, all executive members and non-executive members had a meeting and sat down and
They must have had a meeting because they had to pass a resolution to change the articles to give rights to A1, A2, A3 and not to A4.
The articles, of course, are changed by the shareholders, my lord.
Sorry, I mean, but they had to have a meeting to recommend that to the shareholders.
But it's worth bearing in mind, of course, whether the shareholders include Zedra. So they have the right to vote on any change of the articles that happen.
Yes.
So it's difficult to...
So there's no circumstances pleaded as to how this occurred?
No. So here we are, my lord. We've got a ganging up. They deliberately decide to exclude Zedra. Zedra's a shareholder. It gets sent the articles. It doesn't moan at the time. It just ignored. It doesn't make any contact with it. It has no
That's
deeds.
your doesn't moan at the slightly better doesn't moan at the time point.
Sorry?
That's a slightly better doesn't moan at the time point.
Yeah.
Than the one that they didn't ask for the rights they didn't have. But you say, well, they had a vote like everybody else. They didn't even know how they voted.
No, they didn't. They just didn't vote on anything. They just ignored us, essentially. But that's evidence, which we'll get to try to get there. But in paragraph 37, your lordship says, at its extreme, it says, like, the directors all got together, they passed a resolution recommending to the alteration of the articles, goes to the shareholders, and the shareholders vote on changing the article. And that was done specifically to do down Zedra. I think your lordship is saying, in those circumstances, could that be unfairly prejudicial conduct? We say no, it couldn't be unfairly prejudicial conduct without identifying. You still need the bad faith. You still identify the directors.
Why is bad faith relevant? I mean, if this was done, knowing you had a majority of other people who were not A4 shareholders, in order to do down the A4 shareholders, actually the voting on the resolution doesn't matter because it's the directors proposing it. I mean, can call it bad faith or improper purpose or inappropriate or any language you want, but it would be unfairly prejudicial, wouldn't it?
If there was actually prejudice caused.
Well, that's the lost point. I mean,
you've got to plead it all. You've got to plead your whole case. You can't just say you've done something nasty.
No, but what I'm testing is whether what they allege at its foundation could be unfair prejudice. And I think you accept.
On that one, it possibly could be, my lord. If one says, assume they all discussed it with the other shareholders, with the other directors, and came up with this plan deliberately to put Zedra into a difficult position by effectively forcing them to have to stick with the rights they had and not giving them any further rights in the event that they converted their shares. And you had the necessary intent there. And there's got to be an intent, my lord.
But why is the inference that this was the reason for it not sufficient? I mean, it's quite difficult for them to get board minutes in advance of disclosure so they can see which of the directors were so motivated and get emails to see who was saying what to whom. Can they not say, well, I mean, maybe it is a Sofa case in this respect. They can say it must have been unjustified because it was no commercial purpose. We were the only people left out. A lot of history with us. They never liked us anyway. So they excluded us, and we'll find out later which ones were responsible.
It might work in respect of that allegation only, my lord. It can't work in respect of the others.
But I mean, that's a bit of a slippery slope for you.
Well, I say still, because they've still acted in accordance with there's no suggestion they haven't acted in accordance with the company rules, the company articles. It still needs something more to take it over the top, to convert it into unfair prejudice.
Well, it would be unfair prejudice if there was a deliberate exclusion of the A4 shares from the co-sale rights.
If that had an effect on them.
Well, in one sense it did, because they lost the co-sale rights if they converted, which they did. They didn't have the co-sale rights, which the other converting shareholders did have.
And what prejudice does that cause them if the co-sale rights are worth nothing?
Well, we don't know they're worth. You've told us they've gone, but I mean that wasn't. I don't think they'd gone by the time that was put before the judge.
They haven't.
You haven't introduced that as a ground for us to reverse the judge. This is something you've told us today. So I think there's a difficulty in dealing with that, isn't there? You're saying the petition as pleaded must fail on this ground.
Yes. Well, we say
You're actually now saying it will fail because of something that's more recently happened.
it will inevitably fail, my lord.
Well, even if nothing had happened.
Sorry, I'm saying it will inevitably fail now. But we say,
Yes, but that's not the basis of this appeal, is it?
I'm not suggesting it is.
No, all right. So why? So we're just testing why you say that this couldn't amount to unfair prejudice if it was motivated by a desire. I mean, they were excluded, and there's no obvious reason for their exclusion.
On their pleaded case, that's right.
Yeah.
That is right.
And they add into the mix that the board took steps to refuse access to the register of members at the relevant time. So Zedra couldn't see what was going on, and they had to go and get an order from the Chancery Division before they could inspect the register.
Well,
They
they plead that, yes, as Mr Nabahar-Cookson QC, who decided it, said there was no actual prejudice to them because they'd been given a rather better list.
We haven't got, and I tried to find it on Bailey and it's not there, a copy of Mr Nabahar-Cooksson's judgment.
Oh, it is on Bailey, my lord. Yes, I'm sure.
Well, I couldn't find it.
Can we be provided
Could you provide it?
Certainly, Lord, yes, I'll certainly do that, yes.
electronically for me, please?
Maybe everything's being done now.
I'm just looking at 44 and applying the logic of the discussion we've just had, Mr Ashworth, because it seems to me that in 44 a second allegation is made. The on 38, which is that in all these 13 issues pleaded at allotments of shares, pleaded at 41, the company took steps to dilute the minority shareholding, Zedra, and that was done without offering Zedra the opportunity to participate, and without giving them any information, and was part of a concerted attempt to prejudice its interests. Now, I fully accept that a great deal of joining up the dots is necessary between those allegations, but let's join the dots for a minute and see if it amounts to a row of beans, to mix my metaphors, if you do. So if you were to say, in relation to that allegation, these, the exclusion of Zedra was for no good commercial purpose except that you hated Zedra.
Well,
And other, well, bear with me just for a second. The exclusion of Zedra was for no good commercial purpose except that you dislike Zedra, that you deliberately gave no information to Zedra to enable them to complain and stop it happening, and there was no commercial reason in doing what you did, and as a result, Zedra were excluded and were diluted, and they would have participated had they been offered at market value, at the same value as others paid for the shares. So the result would have been that others would have got slightly less and Zedra would have taken its part. And it's lost a lot of money because the shares have rocketed up since then. Now, if that had all been pleaded out in words of one syllable, would that not in theory be unfair prejudice? The company treating its one minority shareholder, singling out one minority shareholder for bad treatment?
Not if the articles don't allow that minority shareholder preemption rights or some entitlement to be.
I don't think that's
offered.
right, is it? Because here the company is choosing to whom to offer shares at a particular amount, and it on the allegation it has discriminated between its existing shareholders. Now, it may be allowed to do that under the articles. It may be that it can do that. Let's assume that. But it has chosen to discriminate against a minority shareholder on the facts I've put to you.
But no, because we're back to Lord Hoffman and O'Neill Phillips. But what is the rules that govern the relationship between shareholders are those in the articles or any shareholders' agreement. So, absent identifying a breach of those articles, what is it that is done which can be unfair or prejudicial? There is nothing of that nature said.
Well, I mean, they've said, to take a very simple example, the company says they need to raise £1 million. Board of directors say they need to raise £1 million, and they know the company is doing brilliantly well, and the shares are going to go rocketing up, and they're going to issue them at par for £1 million to some shareholders, and they decide to issue them to 9 of the 10 people who are shareholders, but not the 10th because they don't like the 10th person. Entirely entitled to do that under the articles. They know that everybody would take the shares because they're going to rock it up and the company's doing brilliantly well. And there are companies like that, and this was probably one of them. So why is that not potentially unfair prejudice?
Well, because you have to have a right. For it to be unfair, you have to have some form of right which is being infringed. So whether it be the right in the articles, whether it be the common understanding between a family quasi-company that you'll act in this particular way, there has to be some right. You can't just say, they've decided you've contracted with me, and under that contract, I have operated that contract correctly. It may not be in a way you particularly like.
So the directors could issue all the shares to themselves very advantageously, knowing everything was going to rock it up? No.
Well, my lord, that might be a breach of fiduciary duty,
Yeah.
a conflict of interest situation. That's entirely different. These aren't shares being sold to the current shareholders. These are external
Well,
fundraisers.
isn't that the point? Actually, we haven't got. I mean, what I was talking to you about earlier under paragraph 37 is that we have pleaded on the face of the petition a discrimination between Zedra's A4 shares and the other A shares. But when it comes to the issue of shares, there's no allegation of discrimination between different groups of shareholders, because we're not told who the shares were issued to. It's not said that they were issued to the board or their associates, but no offer was made to Zedra. That's no part of the case there. I mean, if it were, then it would be very probably a classic case of unfair prejudice for the board to favour themselves, issue shares at a knockdown price and not to offer them to the other shareholders. That really would be a classic.
I mean,
Well,
what
it's
44.4 does say, it was a concerted attempt by the directors to prejudice Zedra's interests as a shareholder. I mean,
But how?
well, how? By not giving it the offer to take up the new shares.
But
By
it's
the look of it, I mean, I agree entirely with what my lord says, that it's not clear that that's what's being said. But
We have the irony, of course, that the apparent unfairly concerted attempt to dilute their shares actually results, if one looks at 41, in their shareholding going up. Because when we purchase shares in their shareholding
Well, yeah, but
goes
that's a bit of a sort of, where is this? Well, yeah, that's a bit, I mean, but ignore that, because...
Well, my lord, when one looks at the...
I mean, you're right about that, and I think they've retracted that particular point, but there are still a lot of allotments. So the question is, were those allotments unfairly prejudicial? That's the real point.
yeah,
Was each of those elements
Each of those?
separately?
13.
Well, and then cumulatively.
What were each of the directors doing?
Yeah, that's the argument. I mean, of course, many of these allotments took place before some of these people had become directors at all.
Indeed, yes. So,
Difficult to see how they can be rowed into it. But anyway, that would be the nature of the case.
indeed, my lord, but we don't... On Master Rowe's list of points, there isn't any claim here that this is for no good commercial purpose. So there's no claim here that these shares were issued to my brother at a knockdown price. There's no suggestion at all that this wasn't at a full commercial purpose. They say they didn't have the information, so they could, I think, to complain and stop it happening. Well, where is the right for them to stop it happening? They haven't said we have a right under the articles to be offered these shares first.
I mean, I think my lord was onto this long before me. The word dilution is a very slippery word here, because it is undoubtedly used with a pejorative element, but without telling us what the pejorative element is. Dilution can be entirely proper or improper, I suppose, but unless you know what is said to be improper about it, it's neutral.
Well, quite right. One can see a dilution where I issue 100 new shares and I issue them at a price.
Yeah, I mean, I understand, but I mean, when you say it's part of a concerted attempt by the directors to prejudice, I mean, I know this is a conclusory paragraph, and I'm not saying this gives the particulars you need, but it is alleging impropriety of some kind.
But not that it wasn't a legitimate commercial purpose. This isn't a classic dilution case, is that you issue shares.
And I mean, I think it's like I said to you, it's they offered everybody else, not me.
But
I mean, I don't know.
We don't know. I
Well,
mean,
we don't know.
that's not their pleaded case. I mean, that's presumably what you can rely on.
I mean, that is sort of to be implied from sort of some of the way it's put, but it's not said. But I mean, the point I was asking you anyway was, if that were the case, you say that wouldn't anyway be unfair prejudice.
no, not in those circumstances where
Yeah, if it's for a good commercial purpose, you're getting enough money for the company, you need the money, and you choose to offer shares to some people and not to others, that's just fine. I mean, one can envisage circumstances in which that's entirely right. I mean, there's often a bidding war with companies, you know, big tech companies going places. Investors can't fall over themselves to get in, and decisions have to be made by the board as to who to go with.
Indeed, my lord. And where, if one had a set of articles which said you've got to include us, the current shareholders, in that bidding war, and you fail to do that, you can then get yourself into an unfair prejudice situation. But absent a plea of that nature...
Well, that's not said. That's not even close
No,
to what's said here. I mean, it could be. I mean, I can envisage a situation where you could say, well, it's very unfair not to have given us the chance to even bid. But that's not what's being said here.
No, and indeed, and they're not even saying on your list of facts, they're not even pleading we could have bid or we would have paid at the market price.
No, well, you went through that with my lord.
Yeah.
I mean, I am beginning to see it. It's a difficult pleading, isn't it?
It's a very difficult pleading. It's a very difficult pleading for us to know what to do about it. And indeed, it's particularly difficult to know what the witnesses are going to do about it.
Well, Mr Chasty will tell us at 3 o'clock.
My lord, hopefully before that. My lord, there's the reference in all the authorities to Lord Horstichter in Times of Filmy, when he says, don't have to ask for too many particulars because you get it all in witness statements nowadays. Now, of course, with the new witness statement practice direction, that is not going to happen. There is no way that someone from Zedra can speculate as to what was going through the minds of the defendant directors in order to then let those defendant directors know what the case is against them. So at the moment, what am I going to do? I'm going to get 14 directors on board who are going to put a witness statement saying, I am X. At all times, I acted in what I believe to be the best interest of the company.
Well, you could ask, I mean, you could ask, I mean, I don't want to press this because it's all procedural, but I mean, you could ask, against which directors is an allegation of dishonesty made? And that would exclude a lot of directors who weren't on the board at the relevant times and so on. And you could ask which decisions are said to be dishonest.
Is the burden upon me to do that, my lord? Absent them having put up a sustainable case, then it can't be.
Yeah, well, obviously you didn't do it because you wanted to strike it out instead.
My lord, yes. There's a suggestion in my learned friend Scout and argument, paragraph 58, that simply asserting the company's directors acted in bad faith without particularising the state of knowledge and belief of each particular director is permissible because of the judgment in the PV Solar case. And he refers...
Sorry, where are you reading?
I'm not reading from anything, I'm reading from my notes.
Oh, sorry, I thought you were referring... What were you referring to then?
To the my learned friend Scout and argument, paragraph 58.
Oh, I see.
It is said the duty is only subjective, so he wants to get around having to plead the duty, where there's evidence of actual consideration of the best interest of the company. And he refers to the PV Solar Solutions case of Registrar Barber, where she refers to the earliest case, the HLC case, decision of John Randall QC. But this is in the context of the company on the brink of insolvency.
It's miles away.
It's completely miles away.
Miles away.
And you simply can't get around it in that particular way. So what we say? There are 13 purchases or allotments spread over a 25-month period. If one ignores at this point the purchases to increase the percentage share, one is going to have to look at each transaction, the role of each relevant respondent, and examine them at trial separately. And it is not simply a claim, my lord, that the company did this. It's the company and its director. So it's each of the directors. And when I do so, otherwise I'm going to end up with 14 witnesses who simply from their witness statements, I acted reasonably at the time. Full stop.
May have to say I acted honestly as well in the light of these allegations.
Well, my lord, yes, I acted in what I consider the best interest of the company at all times. And that's their witness statement. Because they've got nothing else. They don't know any allegations made against them as to what they did, which is wrong with that. the judge got it round this by saying that there was an allegation of collective ganging up, and your lordship's already picked up on that. The petition contains no allegation of a ganging up against Zedra. And we say it's inappropriate to allow inadequately pleaded allegations of bad faith to survive on the basis the underlying claim is what effectively amounts to an unpleaded claim of conspiracy.
Well, just to be clear, Mr Ashworth, you say there's a significant difference between 38 and 44.
37, 44.
I'm sorry, yes, I keep on getting the numbers wrong. 30, 37, 38, whatever it is, could, in theory, at the furthest extremes, amount to, if they excluded one group of shareholders from a right given to other groups of shareholders, that could amount to unfair prejudice. But letting people take shares in unspecified circumstances for the commercial benefit of the company cannot amount to unfair prejudice, because the directors are perfectly entitled to raise money from wherever they want.
Oh yeah, absent a rule preventing them from doing so.
So you say 44 is in a category of its own and it doesn't add up to my row of beans.
My lord, yes, and 44 is the only thing which is worth arguing about in this case.
And it's the only one where there's any money.
Any money at all. There's a lot of money in it. We think possibly up to 235 million.
No, I understand it's a lot of money.
But it doesn't, just because there's a lot of money doesn't make it a good allegation. My lord, in paragraph 79 we look at the only specific fact which was relied upon by the judge, which was the evidence the respondents, so as to the evidence the response line was the historic dispute between the company and Mr Cookson, which constitutes a breakdown of relations. He deals with paragraphs 2 to 3 of the judgment at page 72. The difficulty with this, my lord, is because that happened in July 2014. It doesn't say which directors he fell out with. It says members of the board. It doesn't say all of the members of the board. And so, my lord, we say that you can't say, well, we had a fallout in 2014, and everybody who's come in since then has also taken exactly the same attitude towards us because of that fallout in 2014.
I thought
the judgment was 2014.
Yeah. I think the fallout, I thought, must have been in 2012 when...
the plea, though, I think, is a breakdown.
Well, they say by
July
he,
2014.
Mr Cookson, as you call him here, resigned from the board, I think, in October 2012.
He did, my lord, yes.
So I was assuming the breakdown occurred then.
Well, my lord, I suppose...
Because he says he resigned then because he was proposing to bring proceedings against the company.
Yes, that's his plea, yes. But the plea is by July 2014.
It is by, but, yeah.
Perfect. So,
I mean, as my lord says, the case heard by Mr Justice Blair was in 2014. One imagines that if there was a breakdown, it had happened.
Well before then, and unless, of course, it was cross-examination of Mr.
It could be.
Cookson,
Yes.
which caused the breakdown. It would be fine.
But he'd left the board.
So, my lord, we say, of course, the breakdown in relationship between Mr Cookson and an unspecified number of unidentified directors of the company by July 2014 is not capable of founding an inference that other individual respondents with whom he doesn't allege his relationship broken down, or indeed he had any relationship with them, or Mr Cookson ill will, let alone an inference they acted in bad faith against them. Well, we say in paragraph 83 that the judge overlooked the mental element of bad faith, and I don't repeat that, it's all in writing. And then at paragraph 84, that the judge erred in holding that if Zedra established a trial of those matters, paragraph 85, which your lordship's already read out, that it would be the more likely inference that they were motivated by bad faith. That disregards the most important allegation in terms of the value which must be attributed to the dilution of shareholding. It's not asserted to have been done for legitimate commercial purpose. And we looked at paragraph 85 where his lordship cited all those things, including no commercial purpose, having in 81 said there was no such allegation. And paragraph 63 of my learned friend's skeleton argument he conveniently skates. Sorry,
So I didn't get the number.
I've given you. Oh, sorry, I might get that. That's right. Paragraph 63, it should be, my lord, of his skeleton argument. The Zedra skeleton. It's page 61 in the bundle, my lord.
Yeah.
This is the inference in relying on Keckman. If you say, seriously, in this regard, it's notable that one in Keckman, Flo J, in concluding the plea of fraud was sustainable, relied inter alia on the absence of any proper commercial explanation for the allegedly fraudulent diversion of funds. Well, that doesn't apply to paragraph 44 in any way, because there's no lack of commercial explanation, let alone a fraudulent diversion. And two, in the present case, the appellants have refused to explain the exigiously pleaded positive case the company's differential treatment of Zedra and other shareholders converting shares to B ordinary shares was for unspecified legitimate commercial purposes. Now that, my lord, is only a reference to the second of the allegations, the paragraph 37 one, which for the reason you've already said is not sustainable. We say the court is bound to proceed on the basis that there was a legitimate commercial purpose here, rather than there wasn't one. And that weighs very heavily against the court being able to draw any inference of bad faith. And it cannot possibly tilt the balance and justify an inference of dishonesty or bad faith. And more generally, so it's implausible that directors of a company such as this, many of whom have never even met Mr Cookson, would act in bad faith towards Zedra while making a lot of money for institutional investors. The fact that there was that falling out between Mr Cookson and some of the directors is not itself again sufficient to tilt the balance towards an inference that all of the directors, including professional directors, as a board, would act in bad faith towards Zedra Trust. Well, as I'm about to move on to ground 5.
Yes, move on to ground 5.
My lords, if one read this petition afresh from the start, the only fair reading of it is that it alleges that the actions of directors in breaching their duties to the company has caused THG loss. And we can see that, for example, from paragraph 49 and the prayer.
49.
Zedra's entitled interest, whether or not compounded, on all sums awarded to it in equity, directly or indirectly, in respect of the director's breaches of duties.
But, I mean, the fundamental problem here is, and to an extent it's a problem of the petitioner's making, there is no loss to the company alleged. I mean, even if there is loss, I mean, they claim, of course they assert a loss to themselves, but there is no loss to the company pleaded.
My lord, there isn't. It was only in the scope the day before that they said there was no claim of.
Well, I mean, that's the end of it, really, isn't it? I mean, obviously the reflective loss principle can only apply where where a shareholder seeks to recover the same loss as the company. But if the company hasn't suffered a loss, there's no basis for the reflective loss principle.
Well, that's right, my lord. But there was.
What's all this about?
This was all about because initially, until the day beforehand, it appeared that they were alleging the company had suffered a loss. Well,
I mean, none is pleaded. Actually, no loss to the company is pleaded, as I can see. Well, okay. But it just pops up at the end, as you say, really in the prayer for relief, which is all a bit odd.
It does, because subparagraph 4 of the prayer for relief is clearly a claim for equitable compensation for loss suffered by the company, out of the proceeds of which the company's to.
I know, but it doesn't actually make sense, does it?
Well, my lord,
I mean, the judge sort of seems to have thought it was an indemnity, but I mean, are you asserting that this petition includes a claim that the company has suffered loss? I mean, apart from the prayer for relief.
Apart from the prayer for relief and paragraph 49, no.
And neither does Mr Chasty.
But it comes down, sorry.
So the parties are agreed that there is no pleaded loss to the company in this case.
Then why is paragraph 4 of the prayer allowed?
Well, that's a fair point. It seems to be, it's not really comprehensible in the light of the absence of any pleading of loss to the company. So that's, I understand that point. But if Mr. Chasty is saying, telling us he is, that there was no loss, they're not asserting a loss to the company, he may have to look again at paragraph 4. But there's no room, is there, for the operation of the reflective loss principle.
Well, no, my lord, that's right. If he's saying there is no loss
To the company.
to the company.
You told us a moment ago that's what he did say,
Well,
the day before the hearing before the judge.
That's what he did say, my lord, but then the judge came up with this idea of an indemnity.
I don't understand that.
Well, nor do I, my lord. He didn't ask
Where
us
does
that.
he, let's see where does he say that? I say I don't understand it, it's unfair, because I haven't reminded myself of how he puts it. But, so this is a...
Paragraph 64.
64.
64, my lord, page 86, the bundle.
So the first is the company. Oh, paragraph 4. Maybe I'm getting lost here. Paragraph 4. No, I'm not.
No, you're not, my lord.
No, no. Paragraph 4 says, in order that the directors of the company involved in the breaches of duty pleaded at 27, 37 and 44 pay equitable compensation to the company for those breaches, and that out of those proceeds the company compensate Zedra for them.
I'm not quite sure what the point is. Is it the other way round, that it's being said that the company's actions, the directors, the respondents' actions have caused the company to be in breach of the information obligation, giving rise to a liability and damages for breach of contract to Zedra, and therefore the wrongdoing respondents should indemnify the company against that liability? If that's what's being said, it's not what's sought in paragraph 4 of the prayer.
It's also not, because 27, well anyway, 37, 38 and 44 are the two breaches we've just been debating.
Yes. Yeah.
So it's breaches, it's the directors breaching their duty to the company not to discriminate against A4 shareholders and not to, and to offer everybody shares that come on up for allotment, including the claimant, said to be a breach of a duty owed by the directors to the company, for which can be compensated in damages which are not alleged.
Indeed, my lord. And of course, 4 says out of the proceeds of that, so it envisages.
It's really no better though than the other point. I mean, if you're right about the other point, this is just a bolt-on.
So, sorry, which of the...
If you're right about ground 4, I mean, in the way you've explained it.
But even if I'm wrong about ground 4, this one doesn't work.
But even if you're wrong about ground 4, this pleading doesn't work, correct?
But this is limited to paragraph 4 of the prayer. This point.
Paragraph 4 and
If you're
paragraph
wrong
5.
about ground 4, this point only goes to paragraph 4 of the prayer.
4 and 5, my lord, yes, because 5 is trying to do...
All the directors involved in the breaches of duty pay such breaches. Well, it could be pay equitable compensation to Zedra for the unfairly prejudicial conduct comprised in such breaches, constituted by such breaches. I mean, again, there's no loss to the company.
Well,
But here they're claiming that you should pay them equitable compensation, I think, for the unfair prejudice that they allege against you.
Well, I don't, with respect, I think it's right, because the only breach of duty pleaded at 27, 37 and 44, the breach of the director's duties under section, under paragraph 9.
I understand the point.
And so, my lord...
Yeah, and that duty is a duty owed only to the company, that's what the
That's right.
says.
and there's no
so
claim.
it can't, it's not, it's probably inaccurately pleaded.
My lord, yes.
But I mean, if you had been caused loss, let's assume for the moment it was found that you were caused loss by the acts of the directors, those acts being A, in breach of fiduciary duty, brackets, causing no loss to the company, close brackets, but also unfairly prejudicial to you and causing you, or to them, and causing them loss, then it would be perfectly proper to order the wrongdoers to pay compensation to Zedra.
That's right, but you wouldn't need the breach of duty as a director.
Well, you might, because that comes back to Lord Hoffman. You have to, the unfairness has to take the form of, for example, a breach of fiduciary duty.
Sorry, I was merely saying this. But if there's unfairly prejudicial
Yes,
conduct,
that's right.
causes
But
loss,
it ties in like that.
whatever the source is.
But this, whatever this isn't the case, is it, for exploring the relationship between the reflective loss principle and Section 996? Because there is no loss to the company involved.
There is now no loss. That's right, my lord.
Well, okay.
And the difficulty is that's pleaded. It's clearly premised on there being a loss, just not.
But there isn't any loss pleaded. I mean, I know the prayer says there is, but none is pleaded.
Well, which is why we say that 4 and 5 have to be struck out.
Which is why you say they should go.
Yeah.
All
But
right.
just think about my lord's question over lunch as to whether really the reflective loss principle is not really in play here. And we'll resume at 2 o'clock, Mr. Ashworth. That's all right.
All right.